everyone. Welcome to our Introduction to Legal Research. My name is Professor Ashley Arrington. I am the Instructional Services Librarian here at Texas Tech School of Law, and I'm excited to give you a brief overview of legal research. So let's go ahead and jump in. So first, you should note that research is an iterative process, meaning that it is a process that need be repeated. It's something that you're going to practice over and over again. And having a process, moving from step to step is going to be most helpful for you rather than jumping into a database and just sort of digging around. So at Texas Tech, we use a 4-step research process, and we'll look today at each of those respective steps. So our first step is a preliminary analysis. We'll talk about what that means. We'll talk about our step 2, focused on secondary sources. Then for step 3, we'll move into researching codified law. And then our final step, step 4, we will move into researching case law. So again, we'll talk about each one of those steps, and let's start with step 1. So again, step 1 is our preliminary analysis. So what does this mean? Our preliminary analysis is where we are basically getting ready to work through our problem and getting ready to do our research, right? So we're looking at the facts, the hypothetical before us, and we are seeking to identify which facts are relevant and material, right? Which of those facts are important to us in conducting our research and seeking to get to an ultimate answer? What are the jurisdictions we're working within? Is there a single or multiple controlling jurisdiction? What is that jurisdiction or jurisdictions? Thinking about the preliminary issues we need to research. So are there certain questions that we need to be asking before we can get into our ultimate legal question that we're looking to research? Beginning to think about potential search terms and phrases. So what are we seeing within our fact pattern or hypothetical? Which of those terms and phrases stand out? What might we be potentially using as keywords? What are some synonyms for some of these search terms and phrases? But essentially, we're just seeking to identify what our knowledge in this particular area is with respect to the question in front of us, as well as our knowledge gaps with respect to this specific question. So what do we know about this particular area of law? And what do we need to know in order to answer the question before us? So again, just sort of getting a feel for where you're at so you can effectively move into the problem. You have worked through this analysis and know where you're going, right? And know how to best structure your searches. So we talked about thinking about potential terms and phrases, right? Using those to create effective keywords or search phrases. So one way to look at this is thinking about those 5 categories that you learned about in grade school. So within our legal problem, we can be thinking about who is at issue, right? Who are the parties involved? What's happening, right? What's happening in this particular scenario? When did it occur? Where is it happening? And then finally, why? So thinking about what types of relief may potentially be sought, as well as the potential claims and defenses that might be presented or used in response. Moving on from there, we'll move into step 2, which is focused on secondary sources. So I'm sure a lot of you have some familiarity with secondary sources already. You can see our definition here is that secondary sources are sources that explain, interpret, and analyze primary sources of law. So they help us to better understand the law. but are not actually the law, right? They're, again, helping us to understand it and be able to better use and apply it. So just a short list of some types of secondary sources here. We've got legal encyclopedias. So our top legal encyclopedias here in the US will be at the state level. The legal encyclopedia is called Texas Jurisprudence, and then the big one at the federal level is called American Jurisprudence. So those can be very helpful resources for you in just getting a broad feel for a particular area or point of law. Treatises are generally written by experts, sometimes law professors, sometimes practitioners. So treatises are also focused on specific areas or points of law, and are very helpful in getting to that next step of your research. Thinking about law journals, so articles that tend to be more specific, more narrow, right, rather than giving a broad overview, but more focused on a specific narrow legal question. Practice guides are another secondary source as well. So generally those are practitioner drafted and sort of giving guidance to where to look first with a particular legal issue, what sort of documents you might look to, what sort of list of tasks you might go through in seeking to prepare for that type of research question. And this is just a very short list, right? So there are a host of secondary sources within the law, but let's talk about the benefits of secondary sources. So secondary sources help us to do a couple of things. First, they help to provide commentary on guidance on specific legal issues, as we talked about, right? Helping us to understand the law before we dig into a more precise legal question. And then they also link us to relevant primary authority. So helping us to research more efficiently, right? We have a better idea of where to go from the start, rather than if we were to avoid using secondary sources and are sort of just digging around on our own. Working through those secondary sources gives us a better idea of where to go next, right? What are some of the top resources that might help us answer our particular legal question? So they point us to the law, right? They help us get to primary law more effectively and more quickly. So we've got a little image here that shows us our primary and secondary sources. We've got two different types of primary law, right? We've got mandatory and persuasive, and we'll talk a little bit more about that. And then we've got our secondary sources, which are always persuasive. Step 3 is focused on codified law. What is meant by codified law? So, codified law, it means that a piece of law has gone through the process of codification. So it has moved through a legal process from which it was initially suggested as a bill, but has been transitioned through that process and all the way has reached that ultimate end process of becoming legal code. So what are some different types of codified law? You can see listed here, we've got statutes and regulations are common types of codified law that you'll often be researching. Codified law can also encompass constitutions or even local court rules. So you'll see that with respect to both codified law and case law, there are a number of ways that we can seek out relevant law. So right now we're thinking about codified law. Again, we're thinking about statutes, regulations, constitutions, etc. So the methods that are listed here, we've got a known citation. If we have a citation for a particular statute or regulation, we can go directly there. We can also use some of our more basic finding tools that, again, you learned about in grade school, but that will be particularly helpful within legal research. So that might involve browsing the table of contents or using the index to get to a particular relevant source. Popular name tables are also a helpful resource within the law. So, for instance, let's say you're looking at a particular statute, you know only its popular name. Let's say it has to do something with the Affordable Care Act somewhere in that area, and you don't know the official legal title, but you do know that short popular name, right? Affordable Care Act, excuse me. So you can work from there to get to relevant pieces of information, just knowing that particular popular name. Then you can identify the actual precise legal area of the code or the actual citation that's necessary to research your issue. And of course, we've got keyword searching, which is something you're familiar with already, but we also have advanced keyword searching. So within the law, there are not just our standard search bars where we're just jumping in and putting a list of keywords or key phrases, but we are using certain advanced search tools where we're able to connect those words and phrases in a specific way. So we can be searching for a particular word or phrase, not only in the same document as another particular word or phrase, or not just alongside that word or phrase. We can look to find resources that are finding those two areas together, right? So we can look for a particular legal issue being discussed alongside another particular issue within so many words. We can look for that within a particular sentence or for particular paragraph. We can use root expanders to ensure that our research results are encompassing multiple versions of a particular word. There are a whole list of what we call Boolean terms and connectors. Hopefully some of you are familiar with those, but we can use those Boolean terms and connectors to build more effective searches. We'll talk about Nexus Uni as a resource that you already have access to, and they have some really helpful guidance in terms of how to build those advanced searches. So if you just look to help, they will give you a list of, or give you some guidance as to how to better build those queries. So we've got multiple different ways of identifying relevant codified law. Again, we've got our known citation using our basic finding tools like table of contents and index, our popular name table, and then our not only just basic keyword searching, but using our advanced search tools using such as Boolean terms and connectors, things that we'll get more familiar with once we start digging into those legal research databases. So kind of thinking about why we're looking first to codified law, which is a primary resource. So we can see here we talked about codified law encompassing constitutions, statutes, regulations, court rules. So we've got all of those things, and each of those things are primary sources, right? They are the law itself, specifically codified law. So why might we want to work and seek out codified law before moving into our next step of the process, which is seeking out relevant case law? So let's say there is a particular statute or regulation that we're working with. We want to know what that specific statute or regulation is before we start looking to cases that help to interpret that particular codified source, whether statute, regulation, etc. So we need to know where that law is codified law and grounded before we go to our next step in the process, which again is our case law step, where we're looking for types of cases that will help us to interpret that codified law area that we've identified. We'll talk about within case law research, there are both mandatory and persuasive opinions. So if you're seeking out relevant case law, you're obviously looking for law that is factually similar, right? So you're looking at cases that are discussing a particular point of law or question of law that is being addressed within the legal issue or question that you're working with. But the difference between our mandatory and persuasive case law opinions is that those mandatory opinions are going to be within our jurisdiction. So only those cases within our jurisdiction can be considered mandatory, whereas cases, even if on the proper point of law or question of law, if they are outside of our jurisdiction, they can only be considered persuasive opinions. Then, of course, we talked about secondary sources, which are, once more, a very helpful starting tool to point us to our relevant primary sources. But you can see sort of the hierarchy here, right? We've got our codified law at top, and then we've got our case law sources, and then our secondary sources, as we said, are always persuasive, never considered mandatory. So let's look to our final step, which is involving case law research. So again, we want to touch on codified law. We want to seek that out before we move into case law. Once again, thinking about weight of authority, right? We were talking about looking at the court that we're in. So we're looking at not only the jurisdiction, but also the level of court, right? We talked about mandatory versus persuasive. Mandatory would be, again, we're working within our jurisdiction and within a level of court that will be binding for the court that we're working in. So if we were in an intermediate appeals court, a relevant case from the Supreme Court would be binding, whereas a relevant case from the trial courts or our district courts would not be considered mandatory, but would instead be persuasive, right? If we're working within a trial court, whether at the federal or state level, opinions that are coming from a Supreme or intermediate appeals courts are going to be mandatory. So again, thinking about what specific jurisdiction you're in, and then not only that, but also the level of court that you're working within, and whether that level of court is mandatory for the court that you are working within. As we said with case law, there are a number of different ways to as we said with codified law, there are a number of different ways to locate relevant case law. So as we said, you may be looking to case law. You may have already identified a specific point of codified law that's relative to your legal question, and you are using case law to help to gain more clarity about that particular area of codified law, right? Looking to the courts to see how they have applied that particular area of law or that particular piece of codified law. You might also be seeking out case law because you weren't able to find relevant codified law. But again, you want to be able to find that codified law first before moving into case law, you don't want to be digging around within case law without knowing that there is a specific piece of codified law, statute, regulation, etc. that is on point, is applicable, right? Again, so now we're thinking about we're within our case law research area, whether we are using this case law to help us better interpret an area of codified law or have been unable to locate relevant codified law and are now building a legal argument based off of the case law research that we are able to identify. So just as with codified law, there are a number of different methods to locate relevant case law. So again, we've talked about known citation. Of course, if you just have that citation for a case, you can jump in and type that in directly, right? You might search by party name, so you've got a name of one of the parties or multiple parties, and you can use that to locate relevant case law. We'll also talk about topic and key numbers as well as head notes. So this is often referenced as the one good case method. And the reason for that is once you get a single good case, you can use these methods to get to other relevant cases. So if you found one good case, you can use what's laid out within that case, which are sometimes called head notes. So head notes give you an overall description of what's happening in an area of law. So that would link you to other cases that are looking to that same legal issue, that fall under that same point of law, right? So you can find head notes on both Lexis and Westlaw, which are your two most popular legal research databases. Topic and key number, same thing, right? You're moving from a topic that's been identified within that one good case that you found, and then you're using that topic link to get to other relevant cases that are on the same topic and that may be of help to you in your own research process. Just using that one case to get to other helpful cases. Now, key numbers are specific to Westlaw, and key numbers are a similar type of tool, right? So there are specific key numbers attached to different points of law. So let's start with like a general area of law and then moving down into more specific numbers. You're getting more and more specific as you move down, right? So you've got a broad area of law and you can use that broader key number to locate broader issues, but you can also go much narrower and find a key number that is specific to a very specific sub-issue within that overall topic and use that key number to get to other relevant cases that are specific to that same issue. So lots of different methods that fall under the one good case method. And these are helpful tools that are presented to us by way of these research databases and the advanced work that their attorney editors have put into just these indexing tools that help us to get to relevant sources more effectively and more quickly. And then finally, as we talked about with codified law, we can also use advanced keyword searching. So not only our standard search bar tool, but also looking to those advanced search functions on either website. Again, we can use different types of Boolean terms and connectors to piece words and phrases together in certain ways, using quotes for particular phrases, using all different types of terms and connectors, root expanders. A whole list of those will be available to you, and those will vary by database. So as you're getting familiar with those databases, it is important to gain some familiarity with which of those terms and connectors are the same across various databases and which of those are unique to its own database, and just making sure to keep that in mind when you build those searches. Another tool I wanted to mention with respect to advanced searching on Westlaw is that there is a newer tool that will suggest synonyms for you. So if you're typing in a particular keyword or key phrase, Westlaw will suggest helpful synonyms for those words or phrases that might help you to better extend your search to include terms or phrases that you might not have necessarily thought of already. So that can be a very helpful tool as well. All right, so let's think about updating the law, right? Very important step. We always want to make sure that the law we're relying on, whether it is codified law or case law, is indeed still good law, right? So this is a hugely important step, and it should be applied within both of steps 3 and 4. So again, making sure that our codified law remains good law, and making sure that our case law that we're relying on also remains good law. So we use one specific tool, again, developed by attorney editors for these legal research databases, and that tool is called a citator. So what is a citator? Essentially, it is an index, right? It is an index of legal materials. And we talked about some of those indexing tools already, but the citator system is what helps us, has built that indexing system so we can use those tools to get to other relevant resources. It is a tool that shows when and how a particular legal authority has been cited. Whether you're looking at codified or case law, you want to look at the other types of codified law or case law or even secondary sources that have cited to the source that you're looking at. So it provides quantitative info. So seeing not only how many other sources have cited to the source that you're looking at, as well as qualitative information. So what sort of treatment has this particular piece of law received? Has it been overruled, right? Does it remain good law? What have other courts said with respect to this particular issue? How has this evolved over the course of time? Is it still good law? So, a couple of reasons for using a citator. So, as we were just focused on, we can use a citator to determine that the case or codified law that on which we're relying remains good law, right? So, we can still use that piece of legal authority as part of our legal argument. So that's one very important piece. And then again, we said that the citator system is an indexing tool. So we can use citators to find additional relevant laws, whether codified or case law, as well as secondary sources that will help us to better understand our legal argument and better build a strengthened legal argument. And so again, thinking back to that one good case method, for example, with respect to case law, we're using some of these citator tools, these indexing tools, to get from that one case to other relevant cases using, as we said, topics and key numbers, headnotes, etc. All of these tools are born from the citator system and can help us to get to additional relevant law. So again, our citator, as a hugely important tool, is our citation index of legal resources. We've got a note here from Nexus Uni, which is a platform that you have access to already as a Texas Tech student. So it's got some instructions here on how you can go through the Shepardizing process, which is specific to Lexis. the citator, using a citator in Westlaw will be referred to as Keysight, and then in Lexis will be Shepard's. So the platform that you will have access to as an undergraduate student is Nexus Uni, which is a limited version of LexisNexis, but it still allows you to go through that updating process using the Shepard's tool. So with respect to that first reason for using citators, making sure that the law on which we're relying remains good law, we'll have particular flags or symbols based on which database we're working within, and those flags and symbols will stand for different things. So they will help to give us information about the status of the codified or case law that we're looking at, right? If it's been overruled, we'll be able to see how it's been overruled, looking to the cases that overruled this particular case, etc. If it's statutory law, we'll be able to see whether or not that particular statutory code remains good law and is still in place, or has it been modified, etc. So this link here is specific to Lexis Uni and walking you through this updating process using Shepard's on this particular platform that you already have access to. So feel free to click that link if you are looking for more information on how to update your research results and ensure that you are relying on good law. So as I said, this is the platform that you'll have access to, Nexus Uni. Working from our main law library page, which you see here, if you pull down under resources, you see a link to electronic databases. And then also if you were to, looking down to that second arrow at bottom, if you were to move into the law library catalog, by clicking on advanced search, you can move into another list of databases and resources. So you could get there in multiple ways. Whether you want to use that link at top or the advanced search tool, each of those will take you to Lexis Uni so that you can further explore that database. So here's just an image that you'll see once you're logged into that database that you have access to now. So you can see we've got a search bar at top. If you were to click on advanced search, you would be able to see what those Boolean terms and connectors are for this particular platform so that you can better build your search. We've also got a link for search tips. You can look by content type. So we can see that we've got links to legal news. If you want to look for a specific publication, you can search by case law, looking for law reviews, right? So we've got a number of different ways that we can locate relevant information if we know what type of source we're looking for. And then you can narrow by date, etc. But really the best way to get a feel for this is to really just jump into the platform and kind of play around. If you do pursue law school, you will gain access to the two top legal research databases, which will include Lexis as well as Westlaw. And so again, this Nexus Uni is a limited version of the LexisNexis, but it will give you at least some level of familiarity that you can take with you into Lexis if you do end up pursuing law as a career path. Okay, so how do I know when to stop, right? We've talked about our full process, moving from step one, doing that preliminary analysis, into step two, looking through secondary sources, and then thirdly, looking to codified law, and then finally case law with step four, and then specific to steps 3 and 4 with both codified and case law, making sure that we have taken the time to use this citator tool, KeyCite or Shepard's, whichever it is, to ensure that the law that we're relying on remains good law. So I often get this question from law students asking me, how do I know when to stop, right? How do I know when I'm done with my research process? So there are a few different indicators that will help you to recognize that you are at a stopping point. So first, we've talked about our 4-step research plan or research process. Have you worked through that process? Have you reviewed all of the relevant resources that you identified in that process? Secondly, thinking back to that first step with your preliminary analysis where you have identified the issues and sub-issues that you need to be looking at. Have you addressed all of those issues and sub-issues that you identified, or are there specific issues or sub-issues that you need to further look into and research? Have you found a precise answer to your legal question? So perhaps there is a precise legal answer to your question. That most certainly will not always be the case and likely won't be the case, but sometimes you have a question where you go to research the issue and there's a particular piece of codified law that's directly on point. So if you found a precise answer, that would be another indicator that you are done with your research process. Are you coming across the same resources again and again? So if you've moved through all of these steps and you keep getting pulled back to the same resources, that should be an indicator, again, that you're through with your research process, because if you've moved through each of those steps comprehensively, that's what's going to happen, right? You're just going to keep coming back to those sources because there aren't other relevant pieces of legal information if you've successfully moved through each of those respective steps. And another one I should have included here is in practice, thinking about in practice, you may just run out of time, right? You're working with strict deadlines in practice, so your boss, supervising attorney might assign you a task and you only have so much time, right? And so you just do the best that you can with the particular time that you've been given. But again, several different indicators for having reached the end of that process. I hope this was helpful to you, just getting a general overview of what legal research looks like and an introduction to that process, moving through step by step. If you have further questions, please feel free to reach out. You can email us at reference.law@ttu.edu. That will bring you to will connect you to our law librarian team, and we can help you with questions via email. You can also email me directly, ashley.arrington@ttu.edu. I'm happy to answer questions if you guys would prefer to reach out directly. And then also you can see it right here, our chat box. So if you go to any page on the Law Library website and you look to the bottom right hand corner, there will be a little red box that you can click on, and then you'll see this welcome to LibChat message, and you can submit your question there, and we can, if we are presently monitoring the chat, which is just during standard business hours, you'll be in direct contact with us. If it's outside of our standard business hours, then we will get back to you in the next business day. So again, feel free to email either our reference desk or me, and then also just take advantage of that chat tool if you want to chat directly from the Law Library website. Okay, well, again, please reach out with your questions. I hope y'all enjoy the rest of your pre law academy. And thank you so much again for your time and attention. Thank you.